Welcome, everybody. We're delighted to have you here. My name is Paula Price, and I'm the host of today's webinar, which is Changes to the Divorce Act Town Hall Edition. And we're delighted to have our guest, John Paul Boyd, QC of John Paul Boyd Arbitration Chambers, here with us today. And before we introduce our speaker, we would just like to acknowledge that the land on which the People's Team is gathered is that of the Coast Salish peoples, and that is made up of the Musqueam, Squamish, and Tsleil-Waututh nations. And we would encourage all of you to think about the land on which you're joining us from today. We would also like to acknowledge the financial support of the Department of Justice Canada and the Law Foundation of British Columbia for funding to today's webinar. And with that, we'd like to introduce JP Boyd QC. JP Boyd is a family law arbitrator, mediator, and parenting coordinator. He's a member of the bars of both British Columbia and of Alberta. He's a returning speaker. He spoke earlier this year in February about the changes to the Divorce Act right before they came into force. He has produced a wealth of information that is available online. He has helped with reviewing the dial-a-law pages that we have about changes to the Divorce Act, and we will be sharing links to that information with all of you in the materials that follow up on this webinar. And JP has, quite frankly, too many accomplishments, achievements. He's a member of a number of organizations, too much to mention in one introduction in today's webinar. Suffice it to say, we are thrilled to have him here with us today. We're delighted to have him, and thank you, JP, for being with us today. How are things for you in Calgary?
Oh, good, Paula. We're having a beautiful sunny day, and I think it's going up to 21, which is different than it was last year when we had a couple of feet of snow. So I'm happy.
Fabulous. Yeah, we're celebrating a rain-free day here in Vancouver as well.
Oh, enjoy them while they last.
Exactly. So we're going to turn to the questions that have come in from our guests. And the first question, JP, is from a sort of high-level perspective, what's your perspective on the changes on the overall impact of the changes of the Divorce Act?
Well, I think that the changes really depend on where you happen to live in Canada. So if you're lucky enough to live in British Columbia, I mean, we've had language that mirrors almost exactly what the new language in the Divorce Act talks about now since like 2013. In Alberta, that language has been used since I think somewhere around 2007, around 2007. But in other provinces like Ontario, Canada's largest province, they're still talking about custody and access. And it wasn't until the Divorce Act came into effect that they actually changed a lot of their key legislation dealing with the parenting of children after separation. So really, the most important thing, I think, from a family law lawyer's perspective is that the Divorce Act amendments have really pushed all of the other provinces to kind of catch up to the spot where, Alberta and BC have been for several years now. On a more practical note, the other important aspects have to do with, taking a truly child-centered perspective to making decisions about parenting after separation in terms of parenting schedules and making decisions about children after separation. Getting judges familiar with the true breadth of the factors that go into making decisions about what is in children's best interests, including, of course, not only children's voices, views, and preferences, but the incredible impact that domestic violence can have when families separate.
That's incredible. Thank you, JP. And that's consistent with what we were talking about back in February, that was the focus of some of these changes was on, as you said, the family violence aspect of it, and bringing the Divorce Act into consistency with the current modern reality of family life. And so our next question is, and again, it's something that we touched on in our last webinar, was the putting priority on outside of court resolutions of family law disputes. And so the next question is, has there been an increase in resolution outside of court, such as through mediation and arbitration?
Well, it's hard to say because, like, firstly, the only kind of public records that are available are the records of court cases that are being decided, because those decisions are published publicly online. You can get them at a website called Canlii, CANLII.ca, which has a fantastic resource of published Canadian court decisions concerning the Divorce Act as well as the local family law legislation. But we don't track mediation and arbitration because those are purely private processes that happen outside the court system. But what I can say, though, and this is one of the fantastic innovations that the Department of Justice has very carefully created and added to the Divorce Act, appears at Section 7.3 of the Divorce Act, which puts a duty on separating parents to consider ways of resolving and try to resolve disputes other than through court, if that's at all possible. The other neat little part of the amendments is at Section 16.1, which actually includes a little tiny, almost a throwaway reference that says that the court can make orders requiring parents to attend out-of-court dispute resolution processes if disputes about parenting after separation are on the table. And there, sure enough, have been a couple of judges who have made use of that section. So that's kind of exciting to see. And of course, if you happen to live in BC, there's nothing new about this for you either. That was one of the key innovations of the Family Law Act when it came into force in 2013, a provision allowing the court to require that people go and try mediation or a collaborative process or arbitration before coming to court.
Fabulous. Thank you, JP. So for our next question, there are some situations that we've heard of where maybe one of the parties to the family law dispute has more resources than another, or it's an acrimonious split, and maybe one or both parties are dragging out the process. Are there changes that make it harder for a party to do that in the divorce process under the new changes?
Well, it's important to remember that in Canada, the way that the powers involved in running a country are divided between the federal government and the provincial governments is all spelled out in the Constitution Act, right? And that act contains at sections 91 and 92 a comprehensive list of the powers that are exclusively part of the federal jurisdiction and the powers that are part of the provincial jurisdiction. And so the problem here is that I am sure that the Department of Justice, well, first of all, they are without a doubt mindful and aware of the situations like what you've described, Paula, which sometimes people refer to as litigation abuse, right? Where you can drag on a court proceeding until the cows come home, really. And actually in Alberta, I'll tell you that the cows come home fairly promptly. So that's a bad metaphor. But the thing, though, is that really, this is something that's within the sphere of the provinces. I'm sure that the federal government would like to do this if they could, but it's really a provincial problem. And so what we see when we talk about the means that are able to sort of compress a process and stop people from dragging it out, well, normally we're looking at the provincial rules of court, the rules that apply to the trial courts in each province and each territory. We're looking at the legislation that has to do with what are sometimes called frivolous and vexatious litigants, which actually allows the court to make rules stopping people from bringing new proceedings without permission first. And then the Family Law Act, again, has rules that allow the court to make special orders when it appears to the court that somebody is in fact abusing the process. But there's nothing in the Divorce Act that talks about that. And that's because rules about that sort of thing are outside the jurisdiction of the federal government.
Fascinating. Thank you so much, JP. So our next question here is, how do the Divorce Act changes improve prospects for a victim of abuse?
Well, this is, again, a function of that split between the powers of the federal government and the powers of the provincial government, right? So from a federal government perspective, issues about domestic violence are dealt with under the Canadian Criminal Code, right? So the Criminal Code contains prohibitions against things like stalking, unlawful confinement, physical abuse, and sexual abuse, and it goes on and on. The Divorce Act takes an approach to domestic violence, which is really about raising awareness of the impact that domestic violence can have on children and on children's well-being. That's the primary focus, right? So the Divorce Act, the amendments, for the first time since the Divorce Act first became law in 1968, has a definition of family violence. And the definition is appropriately broad, and it's just as broad, if not broader, than the definition we see in the Provincial Family Law Act. And so family violence becomes a factor that the court is required to take into account when determining the impact of family violence on the best interests of children. And in fact, when family violence is a factor, there's a whole extra set of factors that the court needs to think about, such as, for example, whether the child was directly or indirectly exposed to the family violence, the frequency of the family violence, the nature and severity of the family violence, whether the family violence involved coercive control, for example. So this end of things really alerts the court to the importance of thinking about family violence in the context of making orders about children. The other place that it comes into I guess, some kind of effect in the Divorce Act is at Section 7.8, which requires judges to consider the presence of any civil protection orders, which is an order that you might get under the Family Law Act, for example, criminal protection orders, orders that you might get under the Criminal Code, and child protection orders when making orders about things including spousal support, child support, parenting after separation, and things like that. So that's all really important. But what the Divorce Act really does, all things considered, is it puts questions about family violence firmly on the radar of the court and makes it a mandatory thing that the court has to think about when it's making orders about parenting after separation. The prospects for victims of abuse, on the other hand, you'll see that more effectively dealt with under the Family Law Act, because again, it's the federal jurisdiction versus provincial jurisdiction. So under the Family Law Act, the court can make tons of orders called protection orders, personal protection orders, that do things like limit spouses or parents' ability to talk to each other, limit how they contact each other, prevent them from attending work or place of education, and so on and so forth, right? So the remedies are going to be found mostly into the Family Law Act in the family law context.
Excellent. Thank you, JP. And quick question. Last time we did this, you were talking about the definition of abuse under the Divorce Act. And I think abuse was broader than physical violence. There was also the emotional and the financial. I think there was one other form of abuse that we had talked about. So is that the same for those other categories of abuse?
Oh, yeah. So in legislation, you'll commonly find a term defined right at the very beginning of the legislation, and that definition applies throughout the entire thing. So family violence is defined in Section 2 of the amended Divorce Act as including physical abuse, forced confinement, sexual abuse, threats to kill or cause harm, harassment, including stalking, failure to provide the necessaries of life, psychological abuse, family abuse, threats to kill or harm an animal or damage property, and actually doing that sort of thing, as well as coercive controlling behavior that causes people to feel fear for their safety or the safety of another person. So it's a really big definition, right? This is not the 1950s when we thought about family violence, we just thought about it in terms of hitting, right? So much more is involved in this.
Thank you for sharing that, for clarifying. So the next question that we have, JP, is how are false allegations of violence handled?
So the important thing about this is, firstly, we have statistics about the frequency with which false claims about things like violence and sexual abuse and child abuse are raised in family law disputes, right? And it's important to understand right off the bat that there are really two kinds of false allegation. The first kind of false allegation is when I say that you've done this thing and I genuinely believe that you've done it, but I happen to be mistaken, right? Then there's the kind where I make the allegation knowing that I'm telling a lie when I make that allegation. And so essentially the two categories are, a claim that's made about the existence of abuse that is made, in good faith, but is fundamentally mistaken, as opposed to the claim that's made in bad faith, knowing that the claim is crap to begin with, right? And so there was a study done by a professor of law at Queens, and I can't remember exactly when this was. It was definitely in the first 2 decades of this millennium. The guy's name is Nick Balla, and Nick is a incredibly prolific professor of law, frequent writer on family law topics, including issues like this. And what Nick found in his study of false claims is that the rate of claims that are made in bad faith, that is, knowing that the claim is false to begin with, is incredibly small. It's something on the order of 3 to 4%. So it's a very small number of claims. So how are false allegations handled? It's going to depend on whether the claim is made knowing that it's a lie to begin with, or if the claim is made in good faith, believing that the claim is true, right? If the claim is made in good faith, thinking that it's true, you just happen to be mistaken, the court, will forgive and move on. But if it is found that you have lied about the nature of the claim, that's when you need to get worried, because from the court's point of view, it's going to cast your credibility in a very poor light. If you've lied about that, what else are you capable of lying about? And if you've lied in oral testimony or in written testimony, then you need to be worried about sanctions for contempt of court, for perjuring yourself, lying to the judge, right? And then, of course, if I'm the judge and I'm making a decision about, are the two of you able to cooperate when it comes to making decisions about parenting after separation, I'm going to think long and hard before I think that somebody who has made an intentionally false allegation is capable of cooperating with the parent, never mind acting in the child's best interests.
So interesting, JP. Thank you for that. And so in those two examples, it would seem that if you make a false allegation, but you make that allegation in good faith, and it turns out that it doesn't constitute violence or abuse, that you would not be penalized. Your credibility would not necessarily be penalized the same way as though it was that other type of false allegation, the one that you know to be false from the outset.
Yeah, I mean, I'm not going to say that there are no circumstances in which that wouldn't come back to bite you in some way, right? But
Yeah.
the fact is that if you make the claim in good faith, believing it to be true, that's a horse of a different color than making the claim knowing that it's crap to begin with, right? Because that second approach, acting in bad faith, suggests that you don't have a lot of regard for the judicial system, that you're prepared to lie and deceive in order to get what you want. And it reflects generally quite poorly on your moral compass.
Exactly. Thank you. Our next question is, in deciding a child's best interests, what are the courts looking to in assessing family violence?
Okay, so the best interests of the child factors are set out at Section 16 of the Divorce Act. And this is a huge change, because the old Divorce Act just said something to the effect that the only thing the court can think about when making decisions about parenting after separation, which it used to describe as custody and access, the only thing that the court can think about is the child's best interests. But it didn't go into any detail about how exactly the court assesses what's in the child's best interests. Well, the Department of Justice has taken a page out of the Family Law Act. In fact, they've taken several pages out of the Family Law Act. And now the new best interest tests appears at Section 16 of the Divorce Act. And it's quite long. And it includes factors like the child's needs, the nature of the child's relationship with each spouse, history of the child's care, and it goes on and on and on. But buried in there at Section 16, subsection 3, subsection J, includes any family violence and its impact on, among other things, the ability and willingness of any person who engaged in the family violence to meet the needs of the child and care for the child, as well as the appropriateness of an order that would require people to cooperate on issues relating to the child. Now, the other thing that the Department of Justice has borrowed from the Family Law Act is not just hey, by the way, best interest factors, think about family violence, but there's a whole extra subsection 4, that talks about the things that the court has to consider when assessing the impact of family violence. And so just like the Family Law Act, when family violence is a factor, it's not just part of the list of best interests, but then the court has an extra step to do in order to assess the impact of family violence. And so under section 16, subsection 4, the court's required to take into account the nature, seriousness, and frequency of family violence and when it occurred, whether it's a pattern of coercive controlling behavior, whether the family violence is directed toward the child, and whether the child is directly or indirectly exposed, risk of emotional, psychological harm to the child, compromise to safety, and so on. So those are all really important to read and to understand. And I think that what the Department of Justice has done in making these amendments is it's not just saying, family violence is an important factor to think about, but here are all the nuanced considerations that you have to take into account once family violence is on the court's radar. And this is really important because it creates a multidimensional portrait of all of the things that are involved in family violence and all of the potential consequences. Among other things, what's important to know is that it's not just, that violence occurs between spouses, but recognizing that it could be violence from a parent to a child, and recognizing that the child witnessing or observing or being indirectly exposed to violence between adults is a form of family violence.
Thank you very much, JP. That's very helpful. So how old must can a child be or at what age can they legally decide which parents they want to live with?
Well, technically, that would be when they reach the age of majority, which in British Columbia is 19, and in provinces like Alberta, 18 years old, right? A lot of people, and it's completely understandable, but they think that when kids turn a certain age, and the most common age I've heard is 12, when you're 12, you can decide where you live. And parents will actually say that to their kids. And this is obviously quite problematic. Firstly, the reality about kids is that as a parent, you are responsible for their care and welfare and upbringing until they stop being minors, until they become adults and they're able to function all on their own without needing parental oversight. And so, you have say, for example, you've got a toddler, or a 6-year-old who says, "Mom, I'd really like to eat 5 gallons of my favorite chocolate ice cream." That may be what they want. But as a parent, your job is to say no. And if you're a really kind parent, it might be, well, you can have a scoop, but I'm not going to give you 5 gallons, right? So the issue here is, you've got a child who says, "I really want to live full-time with dad and not with mom," right? So the problem that parents are dealing with is that, whatever the parenting arrangements are, if they're in a separation agreement, or if they're in a court order, or maybe an arbitrator's award, well, the parents are bound by that. They don't have the discretion to do anything different than what the order or the award or the agreement happens to say. And even if parents don't have that sort of thing, and the child at 12 years old says, "I really want to live full-time with mom or full-time with dad," or whatever the case might be, you still have a responsibility to make sure that the decisions that the child is able to make are within the child's best interests, that the parenting arrangements for the child are in the child's best interests, and so on. And so the answer is that, technically speaking, kids can decide where they want to live when they're adults. And in BC, again, that's when they turn 19. There's another way of looking at it, which is that maybe children can decide where they choose to go to when they turn 16. Why 16? Because 16 is the age at which the Ministry for Children and Family Development will stop arresting your child and forcing them to return to your home if they run away. So at 16, if they can run away and the ministry just says, "Well, here's your exciting foster home that you might want to move to," well, that really is an effective age at which the kids get to make their say. But in fairness to all those kids that are younger than 16 and don't want to make that kind of monstrous decision to have to run away from living with a parent, the reality is this. Under the best interests of the child test, one of the factors that the court has to think about is the child's wishes and preferences, right? And though the impact that the child's wishes have on decisions that parents and judges and arbitrators make changes, right? There's a difference between a 6-year-old who says, "I want a pony," and a 14-year-old who says, "I'd like a pony, and by the way, this is my savings program and how I intend to purchase the pony," right? It's a different, kettle of fish, right? So as children get older, and taking developmental and cognitive factors into account. In general, the older the kid is, the more persuasive what the child wants is going to be on the court. But let me give you a counterexample, right? Let's say you have that 14-year-old who says, I really want to go live with dad, but dad happens to manufacture crystal meth in the basement and sell it out of his garage. That may be what the child wants, but the child's not going to be able to live with the parent who's manufacturing crystal meth in the basement, right? It's just not going to happen. That may be what the child wants, but it's not in the child's best interests, right? So to summarize, age 19 is when kids become adults and they are free of parental control, without a doubt. Age 16 is roughly around when the Ministry for Children and Family Development, the child protection people, will stop forcing kids to go back home if they run away. So that's kind of a worst case kind of scenario, right? But for other kids, the influence that their wishes have take on greater weight as they get older and more mature and more able to intelligently decide what's in their own personal preferences and best interests. But still, until kids reach that age of majority, kids have a voice, but they don't have a choice.
Ooh, I like that. A voice, but not a choice. That's a great way to summarize it. Thank you so much, JP. Our next question is, and this is a question that came in from one of our viewers. One parent is not a resident of Canada. The other is a Canadian citizen. Does that affect the way that guardianship is awarded?
No, because guardianship is dealt with under the Family Law Act. Guardianship is not something that the Divorce Act talks about. The Divorce Act talks about people who are spouses and who have parental responsibilities, have decision-making authority and parenting time with the child. The Family Law Act talks about people who are guardians and have parental responsibilities and parenting time with the child. The way the Family Law Act works when it talks about who's a guardian and who's not is it doesn't really have to do with necessarily who's a parent, right? Because you can be a parent and not be a guardian. And under the Family Law Act, somebody is a guardian if they have lived with the other parent during the life of the child, or if they regularly have cared for the child after separation, or if the two parents have made an agreement appointing the other parent as a guardian of the child. There's a lot of nuances and flexibilities, but the important thing, though, is that what matters is that the parents have lived together during the life of the child, which is why they are by default guardians. It doesn't matter who's a citizen and who's not. It doesn't matter who's a resident of Canada or who's not. The question, the test under the Family Law Act is, did you or did you not live together during the life of the child? Now, if things get complicated, and it's not clear that somebody's a guardian, or maybe they're a parent, but they're not a guardian because they didn't live with the other parent, they haven't regularly cared, then you have to get a court order. Then the question is whether the court has jurisdiction to make that order. Now, there's a similar kind of question under the Divorce Act, right? Because you are a spouse as long as you are married to the other person. It doesn't matter whether you live in separate countries or whether you're residents of Canada, whether you were married in Canada or you were married somebody else. The question is, are you or are you not married to each other? And if you have a child, well, presumptively, you're the people who are able to ask for decision-making responsibilities about children and parenting time with children. The question, though, comes down to that tricky part where maybe there's a legal issue. Maybe you are, maybe you're not. Maybe you should, maybe you shouldn't. And a question like that, the court's ability to make decisions about who should or who can ask for or have decision-making responsibility in parenting time is about the court's jurisdiction. That's a really tricky question. And under the Divorce Act, you have to be habitually resident in Canada in order to, or in the province in which you live, in order to ask the courts of that province to make orders about parenting time or decision-making responsibility. But it doesn't end there. The Family Law Act has its own little jurisdictional problem. And then in British Columbia, there's also the Court Jurisdiction and Proceedings Transfer Act, which also talks about jurisdiction. So to answer the question as simply as possible, there's a whole landmine of legal issues potentially lurking here. And those legal issues, the ones that are really, really hard, have to do with whether the court can make orders or not, right? But underneath all of that, though, right, the Divorce Act talks about people who are spouses, spouses who are parents, and because they are spouses who are parents, spouses who are able to ask for decision-making responsibility, and parenting time. That's the easiest way of going about it. But there's a minefield there.
Thank you, JP, and thank you for walking us through the minefield without anybody getting hurt. That was very helpful. So our next question is something that we talked about last time as well, this idea of relocation. And so how has the legal test evolved for whether a parent can move with a child?
So the cool thing here is that this is, again, the Department of Justice thoughtfully borrowing a page from BC, because British Columbia's Family Law Act was the first family law legislation in all of Canada that included a test for whether a parent can move away or not. The important thing to understand is that it's not just a test for whether a parent can move with the children, it's whether they move with or without the children. And so these decisions are decisions that lawyers call mobility decisions or relocation. Relocation is the term used by the Divorce Act. And the Divorce Act includes a whole bunch of brand new sections from section 16.9 to section 19.96. So that's about seven sections that are brand new that talk about relocation. And what they do is they essentially take a really old Supreme Court of Canada case that was the most important case in all of Canada about relocation issues, and it's been converted essentially into a statute, right? So it's easier to understand, it's easier to apply. It doesn't mean that the outcome is any simpler, but in theory, it's easier because you don't have to find a bunch of cases and read and understand those cases in order to figure out what the law is. You can just go and start at section 16.9 of the Divorce Act and read that for yourself. But the nuts and bolts are essentially this. If you are a spouse and a parent and you want to move away with or without the child, you have to give notice if moving away is going to affect the child's relationship with you or with other people that are important to the child's life. You have to give that notice 60 days before the date that you move. And the notice you give has to say when you're planning on moving and where you're planning on moving to. And you have to include in that a proposal about how you're still going to maintain the parenting arrangements that are, are the fact of how the child's life is structured. The other parent who gets that notice has the ability to object to your wish to relocate, and they've got 30 days in which to do that. And that's really important because if they don't object, the court can very well make a decision that, well, you don't object, then you can move, right? So the parent who gets the notice is 30 days to object. Now, when somebody has objected, so obviously they're arguing about the issue, they don't agree about whether the relocation should happen or not. In that case, the Divorce Act says the court has to make a decision. And it says that when making that decision, the court has to consider the best interests of that child, that really long list from section 16, as well as a bunch of additional best interest factors that only relate to relocation, such as, let's see if I can find that here, the reasons for the relocation, the impact of the relocation on the child, and there's a few other factors beside, right? And then the court has to make a decision. There's some other complications about that, like who has to prove that it's in the best interests of the child. Sometimes it's the moving parent. Sometimes it's the parent who's not moving. Sometimes it's both parents. But that's the key bits and pieces to really be aware of, that if you're planning on moving with or without the child, you have to give 60 days notice before you move. You can give more notice than 60 days, but 60 days is the minimum. If you're the parent who doesn't want the other parent to go, you've got 30 days to object. And if you do object and the other parent still wants to go and you can't make an agreement about whether the move should happen, then you know that you've got to go to court, and you know that the court is going to think about all of the factors that are involved in determining the child's best interests, as well as special additional factors that relate only to parents who plan on moving.
Super. Thank you so much, JP. That's really helpful. Our next question is, how have the Divorce Act changes impacted spousal support?
They have not. The only way, I mean, basically, the amendments to the Divorce Act primarily talk about parenting after separation and all the stuff that's involved in that, the best interests of children, relocation. There's some stuff in there about jurisdiction that has changed and isn't quite the same as it used to be. But and the basic rules about divorce, they haven't changed either. Sorry, the basic rules about divorce haven't changed. Neither have the basic rules about child support and spousal support. The only little tiny tweaks that have been made are things about enforcement and the work that the federal government does with the provinces and with countries other than Canada about enforcing child support and spousal support obligations. Okay, so the three important things that have not changed in the amendments: the rules about divorce, the basic rules about child support, the basic rules about spousal support. The things that have changed: parenting after separation, best interests of the child, family violence, relocation, mobility, moving after separation, and some issues about whether the court has jurisdiction in a particular case. But spousal support has been left largely untouched.
Wonderful. Thank you for that. And for
It
letting
is
us know
wonderful
what's
because
changed.
it would be overwhelming if
And
all that had
well,
changed too. But anyways, yeah.
certainly would. Our next question, JP, is: has the framework for administrative child support been implemented or started to be implemented? And will this be
So
linked to the family maintenance enforcement program in some way?
right. So what I said was that the basic rules about child support haven't changed, and they haven't, right? But under the old Divorce Act, there was each province and territory had the ability to set up an administrative agency that would recalculate child support as needed, usually on request. The new amendments to the Divorce Act have given the provinces and really encouraged the provinces to establish not only an administrative framework for establishing child support, but also changing child support from time to time. And the idea there for those provinces that have that kind of administrative plan is that basically, you know, if you're the person who's entitled to receive child support, or even the person paying it, you go to the agency and you say, it's time to update child support. And they say, okay, give me your income tax information. Then they make the same request of the other parent. And they wait a little bit, and then they get the information together and they recalculate the amount of child support that should be payable. It's not suited for all circumstances because child support can get ridiculously complicated at times. But for people who are, you know, who get a T4 slip, they're employees of somebody else, this kind of program is awesome. But the idea certainly is that this administrative agency has the ability to update court orders for child support to make the amount up to date with the income earned by the payor of child support and the recipient of child support. And that has the force of a court order and can certainly be registered with the maintenance enforcement program. So the change here that I see in the Divorce Act is a really tangible encouragement by the federal government to help the provinces and territories set up these administrative agencies. And if anybody out there is freaking out about the idea that an administrative tribunal would be able to make these adjustments, the basic idea is that it's much cheaper and much simpler to get these kind of routine decisions that aren't very complicated out of the court, to free up court time and free up judicial resources and make decisions about child support in a way that is usually for most people going to be far less expensive than going to court.
Wonderful. Thank you so much for explaining that, JP. That's really helpful. This is our last of these questions before we turn to the live Q&A. Do the Divorce Act changes impact the way property is divided?
No, because the division of property is one of those things that is only within the jurisdiction of the provinces. It's outside federal control. So the Divorce Act, if you're going to make a chart, right, the things that it talks about are divorce, parenting after separation, child support, and spousal support. The provinces, on the other hand, don't have jurisdiction over divorce, but they can also make orders about property. So the provincial family law legislation talks about parenting after separation, child support, spousal support, the division of property, and in some provinces, also the division of debt. So The amendments to the Divorce Act have got nothing to do with how property is divided.
Fabulous. So JP, I'm just going to unshare my screen so that I can see the Q&As that are coming in. And one question that I'll ask in the meantime came in before the webinar. My income has been up and down over the last 2 years because of COVID. I fell behind in my child support payments and need to change my child support order that was made under the Divorce Act. What financial information do I need to provide?
Well, you need to prove that your income has changed the way you say your income has changed. So that will include, among other things, your income tax returns from the period when the change happened. If the change happened because you lost your job, you're going to want to have a letter from your employer explaining what happened so that the court knows that it wasn't your fault that you lost your job, but for reasons beyond your control. If your income went down because you were demoted or maybe laid off, you want a letter from your employer talking about that. Basically, what you'll need to show is, firstly, what was your income for each year when your income went down? And you'll want to be able to show to the court that your income went down for reasons that had nothing to do with a personal choice that you made, that it was for reasons beyond your control.
Super. Thank you so much, JP. So here's the questions that have come in live. The first one is there any impact on prenups?
No. I mean, sort of yes and no. Prenups are contracts, and contracts are a power that's part of the provincial jurisdiction, not the federal jurisdiction, which means that the federal government doesn't have the authority to make rules about family law contracts, right? Only the provinces do that. So if you want to see what the rules are about how family law interacts with prenuptial agreements or prenups or marriage agreements, whatever you want to call them, you're going to find those in the Provincial Family Law Act, not in the Divorce Act.
Wonderful. Thank you. Our next question here is, are there any different rules if one person is not a resident of Canada and children involved who are Canadian citizens for custody?
Well, what this really has to do with is the ability of the courts of Canada, or more particularly the courts of the province in which you live, to make decisions about the kids. And as I said, there are special rules under the new Divorce Act in which the court has jurisdiction to make an order about parenting after separation, as long as one of the spouses is habitually resident in the province in which they live, right? If that's the case, the court has automatic jurisdiction. However, there are other terms of the Divorce Act that say that if the child is habitually resident somewhere else, then the other side of the case can make an application to transfer the court proceeding to that different jurisdiction. And the reasons why the court might do that are, well, the child has stronger ties to that community. There's more information and evidence about the child and the child's best interests available in other jurisdiction, or maybe the other jurisdiction has had previous court involvement with the child and knows the family to some extent. But that's really the impact, right? The question is, what court has jurisdiction to make orders about these things? And it all hangs on the question of who's habitually resident where.
Excellent. Thank you, JP. There's a follow-up question within that question about the spouse lives in another country. How can the court ensure that they attend and or comply with the court orders?
So that's a hard one. In general, there are rules about how you can start a court proceeding in British Columbia and serve somebody who lives outside of the province with notice that the court proceeding has commenced. Okay. If you have properly served them and they have proper notice that a claim has begun in BC, it's up to them to respond to the claim, or they risk the court making a decision without hearing from them, without hearing their defense or without hearing their arguments about why the order sought shouldn't be made and things like that. And then assuming that you go through that whole process and you get the order because they haven't responded, then the question becomes, how do I enforce the order that I've got? And in general, you wind up having to apply in the other country to enforce the order. But the other person who lives in that country will then have the opportunity to say, no, you shouldn't, you can't enforce that order. I didn't have the opportunity to be heard, or the law in Canada is messed up compared to the law of the place where I live. And, and there's all sorts of other things. It's a complicated question. And whenever you have questions about jurisdiction, including within Canada, like for example, we had our kids in Alberta. I moved to British Columbia. She moved to Nova Scotia. Right? Which court has jurisdiction to deal with that case? Whenever you have a question like that, it's really important to talk to a lawyer, because you're going to need really good legal advice about what to do. The last thing you want to do is start wasting your money by filing claims within jurisdictions that don't have the right to hear your case.
Super excellent. Thank you so much, JP. That's really practical and useful information. Our next question here is basically, what is the proper definition of a marriage-like relationship, and how?
Favorite question ever. Okay, so first, the first part of the question is that you have to understand that the Divorce Act only applies to people who are married, right? If you are married, you've had a license to marry from the government in the jurisdiction in which you were married, and the marriage was validly performed, okay? Don't worry about all of that, but you did the whole thing with the license, you paid the fees, you rings, vows, that whole 9 yards, right? What you're talking about really are people that are living together in longer term unmarried relationships. In British Columbia, those people are called spouses or unmarried spouses. Federally, that kind of relationship is called a common law partnership, and other jurisdictions. Like Alberta has the offensive phrase adult interdependent partners, which I just personally loathe, right? But the name changes depending on where you are. Most people think about these relationships as common law partners. So that's the phrase. The thing that makes life difficult is that there is no definition of, what was the term? The unmarried.
Oh, marriage. Sorry,
marriage-like relationship. Yeah. So, but there are a bunch of cases, right? Because in all these jurisdictions that give family law rights to people involved in unmarried common law relationships, there's a test that has to be met. It's living together for a certain amount of time. In some jurisdictions, it's 6 months if you have a kid. In other jurisdictions, it's 3 years. In British Columbia, it's 2 years, but less if you happen to have a child. And so the definition of spouse is it's somebody who's lived in a marriage-like relationship for at least 2 years, assuming you don't have a child. So there's no definition of what a marriage-like relationship is. And so the courts have had to come up with this on their own. And so the reason why this is my favorite question is that there's a fantastic case from Saskatchewan called Yakachuk and Oaks. And in that case, the judge was asked to consider, is this relationship marriage-like? And the judge went on. Some married couples hold hands, others don't. Some married couples go on vacation together, others don't. Some married couples sleep together in the same bed, others don't. And it goes on and on and on. And so the point that the judge in Saskatchewan was quite cleverly trying to make is that there is no concrete single definition about who's in a marriage-like relationship or not. The nature of the relationship is what's important, and each relationship will be weighed depending on its own particular details, right? So the court will ask questions like, did your friends and family think of the two of you as a couple? Did you go out to events together as a couple? Did you entangle your financial affairs together? Did you do chores for each other? Did you share the same bed? Did you have sex together? Did you go on holidays together? And they're going to look at all of those things, but there's no one thing that's going to sort of make the ultimate decision between, is this a marriage-like relationship and is this not? The point, however, is that if you're just roommates, you're probably not going to be in a marriage-like relationship, right? A marriage-like relationship is characterized by these other factors, some or all, depending on the particular couple involved. So there's no definition. It's all widely variable. And if the court's asked to decide whether or not this particular relationship qualifies as spousal, despite not being married, it's going to look at the totality of the circumstances of that particular couple and make an individual decision.
Thank you so much, JP. That was a very helpful explanation. And yes, trying to define what a marriage-like relationship looks like clearly is a consideration of a number of different factors, which will be different for everyone. We have another question. This is, do parties have any responsibility to support children from their spouse's previous relationships?
Yes, the question is whether or not you're a step parent. In British Columbia, the Family Law Act has a test. You have to have contributed to the child's support for a certain amount of time, and then the claim for child support has to be brought within another amount of time. Federally speaking, the question is whether or not the step parent stood in the place of a parent for the child. And there's a whole bunch of really complicated law about that. But you're pretty safe starting from the assumption that if you have step parents that live with you and your spouse, you are probably going to be required to pay child support to them for those children's benefit. However, under the child support guidelines, which is a regulation to the Divorce Act and also a regulation to the Family Law Act, the obligation that a step parent has comes second in line after the child support obligation of the biological parent. So the answer is probably yes, but it won't be in the same amount usually as the obligation of the biological parent.
Thank you so much, JP. And I just wanted to thank all the attendees who have submitted questions. We've got a number more questions. We'll go in them in order with the time that we have with JP. The next question is, any impacts on sponsorship breakdown cases, specifically on sponsorship obligations in immigration? Considering a party has sponsorship obligations, does this affect the decision for parenting time, child support, spousal support, etc.?
Okay, so sponsorship is all about when somebody who is a citizen of Canada wants to, sponsor their spouse or fiance or something like that into Canada so that they can at some point obtain citizenship themselves. The idea with a sponsorship agreement is that a sponsor essentially promises the government that they will take care of the sponsoree, the person who's coming into Canada. And among other things, the sponsor agrees that they'll repay the federal government for any support payments that they wind up making for the benefit of the person who's coming into Canada, such as I think like employment insurance, and maybe provincially it'd be like welfare and stuff like that. But the sponsorship agreement itself is an agreement between the sponsor and the federal government, not between the sponsor and the person who's coming into Canada, right? So in other words, if they're on the hook, they'll be on the hook to the federal government, not to their spouse, okay? The fact that there's a sponsorship agreement isn't going to have an impact on how things are decided under the Family Law Act or under the Divorce Act, because the obligation isn't to the other person. It's, again, it's to the government, a different agency. That doesn't mean, though, that somebody who has been sponsored to come to Canada might not be able to ask for spousal support. And if that's the case, the court's going to deal with that as on its own, right? Looking at the factors and criteria for spousal support under the Divorce Act, the factors under the Family Law Act, does this person qualify or do they not, right? So that's how that's going to be handled. But one's status as a sponsor has got nothing to do with how the court makes decisions about parenting after separation.
Fabulous. Thank you so much, JP. We're going to move to the next question. This may be the last one we have time for, because I know we're almost out of time. Can you please explain how we as legal professionals now have to deal with the issue of mobility? I realize the test now in the legislated instead of having to cite the Gortz case, but I am just trying to figure out, other than now the test being legislated, what else has changed in the heading of mobility? I know there's a notice requirement now as well for parents to provide one another, et cetera, but is there anything else we need to be aware of?
Well, the notice requirement is critical because if somebody who wants to relocate doesn't give proper notice, that may very well put the fundamental application in mortal jeopardy, right? That just may be the thing that kills the application. So the notice requirement is important. And what everybody who's on the line needs to be aware of is the federal government has put the forms that are to be used for giving notice that you're planning on relocating, as well as giving notice that you're objecting to somebody who wants to relocate, online. And you can download those as a form that you fill out, like a fillable PDF, or you can actually enter the information online and you can print that out as a complete form that you just need to deliver to the other side. So notice is critical. Perhaps even more critical than notice is the entitlement to object. If you're acting for somebody who says, hell no, I don't want my spouse to move with the kids to PEI, you've got to file that objection. The objection has to be filed in time. I am sure that we will see cases about when the time limits can be extended, but the proper thing to do is to make sure that it's filed within time. The other thing that gets really complicated about the relocation provisions are how the burden of proof changes, and it flips between parents depending on the parenting situation. And so what I mean by burden of proof is who has the obligation to prove that the move should happen or that the move shouldn't happen. In other words, who has to prove that the move is in the best interest of the child or that it's not. And that obligation switches depending on the parenting arrangements. And so the problem, yeah, no, I think it's safe to say it's a problem. The problem with how the legislation was written is that it uses this language that we don't see anywhere else in describing those parenting situations. So, for example, if the parent who has the quote vast majority of the child's parenting time wants to move, the burden lies on the objecting parent to say why it's not in the best interest of the child. That's right, yeah. And if the parents have, quote, substantially equal parenting time, then the burden lies on the moving parent to prove why the move should happen. And then in those middle ground cases between vast majority and substantially equal, both parents have the obligation to prove whether the move is or is not in the best interest of the child. So this is really difficult because what does vast majority mean? I know what 90% means. I have a calculator and I can figure out if I'm at that 90% threshold or 85 or 70 or whatever it happens to be. But substantially equal, I know what equal means. Equal means 50-50. If we're talking about child support, I know it's the 40% threshold for shared custody, right? Or shared parenting time as it's now referred to. But what does substantially equal mean? Obviously, it includes 50-50. It probably includes 41 or 51-49. Maybe it also includes 55-45, but how far do we go? So that's really hard to figure out. And the only thing that we can do is wait until enough courts have considered the implications of substantially equal and vast majority to decide that 75% is not vast majority, but 76% is, or whatever the case might be. So from the point of view of lawyers and every other legal professional who's advising somebody about relocation, right now, we're still in the gestational phase. We're still waiting for the courts to spit out enough decisions that we can get a sense of where the courts are going with understanding those two terms. And that's the hardest part, because it means that we can't tell our clients whether they're going to succeed or not on their case.
Thank you so much, JP. That is really helpful in clarifying. We were going to let you go at the top of the hour, and
oh, geez, it's that time, yeah.
So we're going to say a quick goodbye to JP, and thank you, JP. We really appreciate you being here today. We want to make sure you get to your next appointment on time.
Yes. I have a meeting, so thanks very much, everybody. I've got to go, but thanks very much, Paula. Thank you to Drew and everybody else at the People's Law School. This kind of a program is such a good use of our public dollars and public legal education, and I'm so glad the People's Law School does programs like this, but also programs on things like employment law and relations between neighbors and everything else. So thank you very much, the People's Law School, and I will see you all later.
Thank you again, JP.